the recording is now in progress. Okay. Excellent. So, Claudia, I believe we have about an hour this evening. Is that our target?
Yes.
Okay.
Yes.
And as will soon become apparent, I can be kind of chatty in these presentations. I'll do my very best to stay focused on the time we have, but I'll also let you know that I'll stick around to make sure that there's an opportunity to answer any questions that you may have. And as Claudia said, please put your questions in the chat through the course of our discussion, and we'll be able to, we'll get through them all before we're done. So with that, here's where we're headed. When we're, hold on one second, I have this screen sharing bar, which is blocking the top of, you'd think by now we would really sort of understand all this technology. So in terms of just an overview of what I'm going to be talking about, we've got 4 different categories of areas for planning that I hope helps to bring a degree of coherence to the plans that you are envisioning for your child with disabilities. I know that these are that the questions of your child's future keep you up at night and are a topic of regular conversation. And there's so much detail and so much complication in that kind of perspective. And so my hope here is to try to fit some things into some general categories to bring some coherence and order to this process. So what we're going to be talking about first are government benefits, kind of an overview. We're going to talk about supporting decision making, and you know, questions about guardianship and alternatives are going to be in that part of the program. And then we're going to talk about your own estate planning and protecting wealth for the benefit of your child when you're not here. But then more broadly, I want to take some time to talk about planning for a good life. What's the long view that we want to be thinking about? It isn't just these sort of specific and very task and to a certain extent legal oriented things. It's important to be thinking about what other steps can we take to help to ensure that our child as they grow has a good life, and especially when as parents we're not here anymore. Given that this is a lot to cover in an hour, I just want to let you know that I'm going to be covering these things at a somewhat high level, and any one of these 4 topics, it could take up a whole presentation in and of itself. And so in addition to the materials that you'll see here, there's also a list of resources at the end of my presentation, which can help to expand on the things that I've spoken about. And so this is the list of things, and then here's a graphic to help kind of get a sense of how do these different areas fit together. Government benefits, supporting decision making, which really comes into play as your child approaches 18 and that threshold of adulthood. Your own estate planning and that envisioning the good life. We're going to get to them all. So let's start out with government benefits. I think it's helpful to think of these benefits in sort of some organizing categories. We have income benefits, money, we have health insurance benefits, and we have goods and services and supports. So there's a lot of different things that populate those areas, but I think there's income benefits, health insurance, and services and support. So we're going to start first with income benefits. And one of the most commonly addressed one for young people with disabilities is SSI, Supplemental Security Income. This is a benefit from the Social Security Administration, but it isn't real Social Security. That is an important distinction. SSI is a benefit that is specifically for individuals who are considered disabled according to very specific definitions and who have very, very limited income and resources, who are very poor. That's really what SSI is about. If you think of it, it's sort of like the bottom curve of our safety net, our social safety net. It provides a monthly income of a maximum in this year of $841. That's intended to provide for somebody's food and shelter. That's a pretty tough fit to get food and shelter out of $841. We realize it's not a realistic figure to really accomplish those things, but that is the purpose of SSI. The resource limit for SSI is very, very harsh. It's $2,000 for an individual and $3,000 for a couple. But what goes into that resource limit is really important to understand, that what is considered countable for purposes of determining one's resources is sort of a narrowed version. SSI is looking at things that one has in one's own name, as opposed to in a special needs trust, for example, or in an ABLE account. So things in one's own name. And many things that we own aren't countable, like a vehicle doesn't count, one's home doesn't count, one's personal effects, things that you have in your home that you use on a regular basis, those don't count. Nonetheless, this is a harsh limit, and it hasn't been changed since the 1980s, which is pretty scandalous when you think about it. SSI eligibility brings with it in Maryland eligibility for Maryland Medicaid, or medical assistance, and we're going to come to that in a second. Once an individual has reached the age of 18, their parents' finances no longer are considered in determining SSI eligibility. So many of the families with whom we work don't apply for SSI until after their child has turned 18, at which point only that young person's income and resources are considered. This is just a small hint. When you apply for SSI benefits, wait until the month after your child turns 18. Because of this quirky rule, which I ran into when coming with a family to make the application, which I don't do very often. And because it was still in the month that the young man had turned 18, they basically wouldn't entertain the application yet. So word to the wise, wait until the next month before you apply. And there's no deadline. You can apply for SSI at any age, but again, before the age of 18, when the child is a minor, the parents' income and resources are considered. After 18, they're not. The other primary income benefit that we have for individuals with disabilities also comes from Social Security, and that's Social Security Disability Insurance, SSDI. Wouldn't it have been nice that they had a little bit different, more different name, that we don't have SSI and SSDI, which sounds so close together? This is a benefit that is a true entitlement, and so it's not financially tested as SSI is. It's an entitlement based on work history and payment of FICA taxes, those Social Security taxes. And it can be based either on one's own work record or, in certain circumstances, on a parent's record. So as I said, this is not financially tested the way that SSI is. There's generally no income or asset limit. As someone from Social Security said to me once, you could win the lottery and still get SSDI. My little caveat to that is, if the individual is able to work beyond a certain degree, then those earnings count, and that can jeopardize eligibility for SSDI. But generally speaking, unlike SSI, SSDI is not concerned with one's other income and resources. If you become eligible for Social Security disability insurance, it makes you eligible for Medicare, federal health insurance, after 25 months. And I make note, there's a special benefit for people who are disabled in childhood. And for this purpose, it means before the age of 22. Someone who is disabled in childhood and is considered continuously disabled can collect under a parent's work record when that parent becomes disabled before retirement age and the parent begins to collect Social Security, or when the parent reaches retirement and begins to collect Social Security, or when the parent dies. This is the disabled adult child benefit. And this is a change that we see very frequently with individuals with intellectual disabilities, that as they grow older and their parents age and pass away, that often that child will transition from SSI to SSDI under the parent's work record. I've used the term disability a number of times already in this talk, and I'm sure you've had the experience that people mean really different things when they say disability or disabled, that their definitions may vary depending on the context and who we're talking to. So for purposes of Social Security, the definition of disability for an adult has to do with the individual's ability to work and to earn beyond a certain degree. And the terminology they use is that the individual is unable to engage in any substantial gainful activity. So it isn't there are many, many people on these two benefits who are working, but they're not able to work and earn beyond a certain degree. And that they're unable to do so because of any medically determinable physical or mental impairment or combination of them, which is either expected to last more than a year or to result in the person's death. The value of the substantial gainful activity changes every year. It's around about $1,300. So the notion is that the individual is unable to work and earn more than roughly $1,300 a month gross. And that's so what's very important here is that, generally speaking, the disability criteria for Social Security is not based on diagnosis. And that's very important. There's a very small list, like 200 very specific diagnoses that are considered to be an automatic determination or finding of disability, but it's a very limited list, and it tends to focus on things like very virulent cancers, things that have a very known progression, and so forth. So it's going to be important in the process of applying for SSI or SSDI benefits to demonstrate through medical records and input from medical and other clinical folks that the individual's condition makes them unable to work to this degree. It's not just diagnosis. This also includes the child's criteria for disability, which is more about function and not about work, right? That makes sense. It's about kids and their ability to function essentially as in comparison to a typical child. So those are the income benefits that are potentially out there for someone with disabilities. The next category of government benefits is health insurance. And here we start with Medicaid. We call this medical assistance here in Maryland. And it's important to know that the medical assistance program in Maryland actually has about 60 different sort of subcategories. Okay. And the kind of basic, what we think of sort of basic walking around health insurance that we get from medical assistance is referred to as community Medicaid. And that is really comprehensive health insurance. It is often delivered through a managed care arrangement with a provider group, but it's basic health insurance. And it's actually quite good health insurance from the point of view of there's no copays, there's no premiums, there's no deductibles. Generally has fewer limits than private health insurance. It's one of the few places in which we can get help for personal attendant care for people who need assistance getting up and going in the morning and prepared for bed in the evening, that may need hands-on care to maneuver through those kinds of activities. Private health insurance doesn't cover that, but the Medicaid program often does. And eligibility for Medicaid is a requirement for waiver eligibility, which is going to be very important to the kids that we're talking about here. And I'll come back to waiver eligibility in a second. The Medicaid program is financially tested. It's means tested. Your income and resources are a factor. I mentioned that there's so many different kinds of Medicaid programs under that rubric, that umbrella, and they all have actually different limits. And so it's really important so with SSI, you automatically get community Medicaid, but there are other Medicaid programs which your children might find beneficial, which may have different financial eligibility rules. I mentioned Medicare a moment ago as the federal health insurance that becomes available to someone who is on Social Security disability insurance. This is also comprehensive health insurance. We generally think of this as something available to people over the age of 65, but as I mentioned before, it is an entitlement for people who are on Social Security disability insurance and have been for more than 25 months. If someone is dually eligible for both Medicaid and Medicare, the Medicaid program actually picks up most of the out-of-pocket expenses that Medicare leaves on the table. So in a sense, the Medicaid coverage functions as government-paid Medigap coverage. Medicaid picks up the premiums, the copays, deductibles, and so forth. And in contrast to Medicaid, Medicare is generally not means tested. Now, this is really the biggest part of our government benefits, particularly relevant to your children, and that is the services and supports that the government can provide for folks with disabilities. And I mentioned waiver programs earlier. Here we're talking about programs that can, particularly for the developmentally disabled community. These are the programs through which, once they come out of school, that they can access supports and staffing and so forth for their daily activities, which might include employment or other meaningful day programs related to employment, job coaching, job supports, job finding, and other kinds of assistance. Most very significantly, this is the type of program through which people can engage and be provided support staff, which for many individuals with IDD is a really crucial part of the kind of support that they need. It's through this kind of program that that residential care can be available to individuals, as well as respite care. So, in referring to the waiver program, these are programs under that umbrella of the medical assistance or Medicaid program. This is a set of programs that target very specific audiences with specific sets of services and supports, and it's built on a foundation of community Medicaid. And I highlight the Community Pathways Waiver, which used to be known as the Developmental Disabilities Waiver. This is the program through which children coming out of school are able to transition from the entitlement environment in their educational context into the eligibility environment coming out of the school system. And it's these programs through which they are able to access the kinds of supports as well as health insurance that will be so important for their enjoying a good life in the future. Other examples of waiver programs, there's an autism waiver program, which has an incredibly long waiting list. There's a model waiver for medically fragile individuals that provides medical assistance for young people who have very severe medical conditions that would otherwise result in their being in a hospital setting. I'll just note that the term waiver has to do with the state getting permission from the federal Medicaid program to develop these targeted programs for targeted populations and to deviate a little bit from the standard Medicaid rules, such as the waiver programs are able to limit enrollment. And so there's some waiver programs for which there are waiting lists. They're able to offer an increased income limit for access into these programs, which is very helpful for those individuals whose parents have passed away and the child is now collecting the parent's social security from the parent's social security and they have a higher income. So the term waiver has to do with not something that you or a participant is waiving, but that the state got special permission from the federal government to put together these special array of services for targeted populations. And wait, there's yet more services and supports. Food stamps, which can be very important for individuals on the limited income for SSI. Housing subsidies, which is going to be more and more important for our young people who, eventually may move from the family home and may be able to live more independently and not necessarily need to be in a group home or a residential environment, but may be able to live more independently in the community, but could really benefit from the subsidy for housing. These are programs that all of these have financial tests. They are all means tested, and all of them have different rules. So something just to be aware of as your child is growing older and particularly as they're beginning to see that transition coming out of school, that as you learn more about the benefits programs that are available, it's important to recognize that they do have different eligibility rules. And so it's a little complicated, but there's a lot of services and supports available, perhaps through the Benedictine school, but also through organizations that are affiliated with particular disability groups such as autism or Down syndrome and so forth, can be helpful resources in better understanding how to navigate through these different approaches. So that's the big picture on on public benefits. Just pause and take a breath. So as you think back to that graphic, we talked about public benefits, and then the next one over was supporting decision making. This is of particular interest and I would say probably concern for parents of young people with intellectual disabilities who are approaching the age of 18 and becoming legally an adult. And it's something that we often talk with clients about, and we get many, many inquiries about. And what I've learned over time in my practice is that families often have goals that are quite consistent from sort of one family to the next about decision making as they're anticipating their child turning 18. And I found that they kind of fall into these categories that that parents really want to respect and support their child's autonomy and their independence as much as possible, to really um, uh, you know to recognize that as an adult that they do have rights, and they want to encourage that expression of autonomy and independence as much as possible. And we find that parents really want to have what I refer to here as a legal role. And I think what that really means more is a legitimate, a recognized, a respected role in assisting their child with more complex decisions, and also to be able to have access to information. Um, I think for every parent, we want to try to protect our kids from being ripped off, from being taken advantage of, from making foolish decisions, and so that sense of protection is an important part of what parents have on their mind. Um, and I think also wanting to be able to remain involved in some way in their child's important decisions in the future, and that is particularly pointed in my experience when a child may have moved into a residential setting away from the parents and are in the care and support of organizations, that sometimes that can create some barriers between the parents and their adult child in that living situation. And I've certainly found over time that is something that concerns parents, and they want to look for vehicles to overcome that. Um, when we talk about decision making, the really kind of fundamental question here is about capacity. It's about someone's ability to understand a, a decision, to understand what is it that's being decided, what are the choices, what are the consequences, um, w- w- and how can those be expressed? So the notion of capacity to make decisions is very situation specific. Someone may be able to make choices about their day-to-day activities and what they eat and where they go and what they want to study in school. Um, that may be their ability to make those decisions may be different from their ability to make more complex financial decisions, just as an example. So think of capacity in the context of a specific set of circumstances or decisions. And as I work with families and young people with disabilities, um, I often will look to the the input from the young person's physician to get a medical assessment of someone's capacity for decision making. So about their ability to understand questions like, you know, do you understand what it means to be an adult, and that you have the right to make certain decisions now, which you didn't before. And so often when working directly with a young person, and again, I keep saying young, but in this situation, we're talking about somebody who is over 18. I will ask for a physician certificate to get their input on the individual's capacity. But then I still, as a lawyer, I still have to reach my own conclusion from my own interaction too. It's helpful to think of capacity on kind of a continuum, like so many things in life, sort of on a spectrum of more or less capability for certain types of decisions. So by way of illustration, if we have an individual here who is able to make decisions about who they would want to help them in taking care of their money, or communicating with their doctors. If the individual is able to, on a voluntary basis, meaning not being coerced and bossed into it, on an independent basis, meaning able to reach this conclusion themselves, as opposed to sort of just acquiescing with something that someone asked them to do, and to make a knowing decision, meaning that they can understand the effect of the decision that they're making. Well, if someone is able to meet those different criteria, then they may well be able to do a power of attorney and a medical advance directive, legal documents of their own. And when I'm meeting with a young person that is has turned 18, and we're talking with that person and the parents about decision making, I start here. I start with, is this person capable of making this kind of decision in an independent and voluntary way? And do they wish to put in place legal documents that will allow other people to be part of their decision making process? And those two documents, as I said, are, one is a financial power of attorney. So this is a legal document where someone can name the people who they give permission to act and be involved in their property and financial and legal affairs. The person chooses their own agent, um, and importantly, it can be changed. They can fire the person that they appointed, and they can do a new document. And very significantly, the person who is giving power of attorney isn't turning over authority for all their decisions. They're not relinquishing their continuing right to make their own decisions. It's more of letting somebody into the room, as it were. For those of you old enough, as old as I am with my gray hair, if you remember Get Smart, when you were a TV show from long ago, they sort of joked about the cone of silence. Sort of the notion that you would sort of be able to come into this um, uh, sort of protected place where people could communicate in secret. Um, Sorry, that was sort of a tortured analogy. Sorry about that. But also importantly, it, entering into signing one's own legal documents actively engages the person in a really important act as an adult. This is something that's important for planning for their future. So this can be, if the individual has capacity, this can be a very powerful and useful document. Over on the medical side, we have sort of the analog, which is advanced medical directives. And these two are legal documents where someone can name the people they wish to be involved in their medical decision making if the person's not able to do it themselves. And again, here it's something that is flexible. It can be changed. They can name different agents. They can cancel one document and do another one. And they're not relinquishing or giving up their ability to make their own medical decisions. Sometimes it happens that the young person may not have that degree of capacity to be able to make these kinds of decisions. And so we have many other tools that are available to help support people in their decision making and to help them look after their finances that are not as extreme as guardianship. And these are referred to generally as less restrictive alternatives to guardianship. That's an important term that we're going to come back to. So here's some examples of less restrictive alternatives. If we talked before about SSI and SSDI, in the process of making application for those benefits, it may well be that a parent is going to be appointed as the representative payee. It's kind of like the agent for the young person's Social Security or SSI money, responsible for looking after that and also maintaining their eligibility criteria. Other agencies like the VA will appoint a representative payee if their recipient isn't able to manage funds. So that's a vehicle for managing that flow of income from Social Security. You might have a joint bank account with your child, and if both of you are on a bank account, both joint owners have the ability to use and manage those funds. And so that's an alternative to being able to manage assets. Your child may have what we sometimes in shorthand referred to as an UTMA, a uniform transfer to minors account, a custodial account, may be funded by a grandparent when the child was born or when they were young. These accounts are protected until the young person turns 21, and the custodian has the authority to access these funds and use it for the child's benefit. An ABLE account, which we'll touch on again a little bit later, is another example. A trust is sort of a final example of an alternative for managing assets for someone else's benefit. And you know, in combination, some of these different vehicles may really be able to take care of all of an individual's financial circumstances without the need for a power of attorney or without the need for a guardian. I will point out that these examples can sometimes come to an end if the external circumstances change. For example, if we have somebody who has a representative payee for their Social Security or SSI, and maybe they have a trust that was set up by their parents, but if that person has an accident and they receive an insurance settlement as a result of that, that's their money legally, but the representative payee for Social Security doesn't have any authority to do anything with that money. And a trustee doesn't have the authority to act on that person's personal assets. And so that's kind of just sort of an example that sometimes we may need to shift from one of those alternatives to another as circumstances change over the child's lifetime. On the medical side of things, we have a couple of alternatives in terms of medical decision making. Under Maryland law, under our Healthcare Decisions Act, we have a statute that speaks to surrogate decision makers. And what that means is that we have a structure to identify who has the legal authority to make medical decisions for someone who's not capable of doing that for themselves. And we start out by looking to see, do they have a guardian? And for our example, we'll say they don't have a guardian. Then we'll look to see, do they have an advanced medical directive? Have they given a permission to someone through a written document? And if the answer to that is no, we then look to a list of family members by kind of in order of proximity, who by law have authority to make medical decisions. And we start with, after we've eliminated, if there isn't a guardian, we'll look to see, is there a spouse or domestic partner? Is there an adult child? You can see that the statute was originally conceived of thinking of elderly people. But then we get to, is there a parent of the individual who is present and willing to make decisions? And also, is there an adult sibling of the individual? So I work with many families who do not have a guardian for their adult child with significant disabilities, but they know that they have authority through this surrogate decision-making statute to be actively involved in their child's medical treatment without having to be the guardian. Something that we often kind of overlook, and that's just the notion of consent. The young person can speak their consent or request that it be noted, for instance, in their medical record, their consent to allow someone else to be present during an examination or to take part in conversation with the doctor or other providers. While this may not be as encompassing as the appointment of an agent under a advanced medical directive or a surrogate decision maker, it is an important way to be able for that individual to be actively involved in their choice and communicating their choice about who can partake in information and decision making. And I very frequently recommend to families before their child turns 18 to have a chat with the medical staff where your child is seen, and to let them know what you're thinking in terms of supporting your child's decision making. And sometimes that preliminary conversation can help kind of smooth the way after turning 18. I've heard many stories from parents who say, you know, the first appointment after my kid turned 18, you know, somebody sort of rolled that sliding glass, you know, sort of barrier past the desk and said, I can't talk to you anymore. Your child's 18, you have to be there, you know, his or her guardian. It's like, not so. It's not so. Something that is very, very exciting around the notion of decision making has to do with the enactment during our last legislative session here in Maryland, the enactment of a supported decision making law. And this is really a really good thing for individuals with disabilities. And Maryland has joined now, I think more than half of the states and Washington, D.C. now have enacted or are actively considering supported decision-making structure for individuals. And what this does, and I don't by any means claim to be an expert, and it literally just passed in the last month or so, you're going to hear and see a lot more about supported decision making. And that really is what we call in law a term of art. It means something concrete. And what this does is allow an individual, you know, to kind of do the same thing that all of us do when we're making big decisions, like buying a car, buying a house, figure out, you know, getting a new job. We talk to people whose opinion helps us understand and clarify questions, who can help us work through important decisions. I said opinion, I should have said support was a better word. But it's kind of, it's sort of a natural thing for us to talk to people when we're trying to work through an important decision. And what this statute does is to kind of formalize and recognize that that is a valid process to that should be recognized and respected in the legal environment. So essentially what supported decision making does is it enables individuals to make and to communicate and to carry out important decisions with the support of people whom they've chosen and whom they trust to help them work through this decision. This isn't about surrogate decision making where somebody else is deciding. This is about helping someone to understand, to provide information in a way that people can understand, to help them weigh the pros and cons. It's really about a process that can help people to reach their own decisions in a supported and respectful way. And what this statute does is to give heft, to give validity and respect in a legal context to people having this kind of supportive environment in which they can make those decisions. And what I think we're going to see is that supported decision making is going to be recognized as another alternative to guardianship. Like I said, because this is so new in Maryland, it's been around for as a policy goal. It's been around for a long time, but you're going to be seeing a lot more information about this over the next year. So I've gone through all these different things that are potential alternatives to guardianship, and let's just, for the sake of our discussion, consider that these other things don't work. So briefly, guardianship is a legal process that takes place in the court system that it determines that someone is not capable of making or communicating decisions about their person or their property, and that it's appropriate for the court to appoint someone to do that for them. And this is a process that will initiate a very long-term relationship with the court, because it's actually the court that takes on that guardianship role, and then they delegate it to the people who we think of as the guardians, and then we call them the guardians, but it's actually the court that retains this responsibility, and the people appointed as the guardians have to be reporting back to the court every year in a quite detailed fashion. So it really is a long-term relationship with the court. And I think one of the most important things to recognize about guardianship is that it does take away one's rights to make decisions. And that's just, it's very important to remember that. And as you consider this important phase of your child's life and your child's goals and your goals in terms of decision making, you're going to want to take some time and think about these different approaches reflective of what your child's capabilities are to help arrive at the right decision. Um, I'm moving on to the next turn of the wheel, and we're going to talk briefly about estate planning. And I just want to start out by saying this is not something just for people like Bill Gates and Warren Buffett and, Madonna, people who have tons and tons of money. Estate planning is something that's important for every one of us. It really is. It is something that is important to lay a solid foundation, both for yourself, but also for your kids. And it's also important to think of estate planning as a process. I always kind of wonder when I hear people say, "Oh, it's a process." That means like I'm never done, right? It's just going to like go on forever. Like I'm going to have to keep doing this. Um, it is something that you will need to revisit from time to time. So I don't want you to think of your estate planning as something that's sort of a one and done thing. Um, so in broad strokes, estate planning is about deciding what assets that you have that you want to leave to or for the benefit of other people, and how you want to do that, both during your lifetime and also when you die. But also, while you're here and living, to think about circumstances where you might not be able to make your own decisions or might not be able to take care of yourself. So estate planning is also about your own decisions and documents, powers of attorney, and medical advance directives. So it's both, it's a big picture kind of notion. It's what do I want to leave behind when I die, but also what kind of protections do I want to put in place for myself, so that I can continue to be helpful to my family, but also get the help that I might need. Um, Something that often comes up in discussion about estate planning, and this is one of those slides that's like really long and tedious. That'll be something you can take a look at later. But in short, I would just want to hit on a couple of very common questions: what's probate, what's a will, and what's a trust? So the probate process is taking place in the Orphans Court and the Register of Wills in every county in Maryland. And its purpose is to identify what somebody left when they died that was just their own, just in their name alone, and that didn't pass to the next owner when the person died by some other vehicle like a joint owner or a beneficiary designation or something that was in a trust. So the probate process is about identifying and verifying and valuing and accounting for what you left behind when you die that you didn't otherwise leave to someone in a way, like I said, by joint ownership or beneficiary designation or in a trust. And it's really important to know that your will only controls the things that go through probate, only controls what goes through probate. And so coordinating what you leave that might be subject to probate and what is not is really important, so that when you die, things go where you want them to go. And part of what that means is you can expect when you would go and talk to a lawyer about estate planning, they're going to send you a very nosy questionnaire. They're going to want to know all about what you own, what your income is, what your retirement accounts are, what your debts are. We need to know this whole picture so that we can help plan to accomplish what you want. So I just want you to be prepared for that. For those of you who may not have worked with a lawyer before, that they're going to ask you a lot of information, and they have a duty to keep that confidential just between the two of you. Last little bit on vocabulary. A will is a specific legal document that has kind of one purpose in life, and that is to direct what's to happen with your probate estate when you die. The will's moment in the sun is when you've died. A will during your lifetime is just kind of sitting around waiting, for its cue to come on stage. Your will can be changed at any time during your lifetime, but its real moment is when you've died, because it's going to give direction for how certain of your assets will be handled when you pass away. Importantly, for those of you who have minor children, another really important function of a will is where parents can identify who they want to be the guardians of their minor children if the parents die prematurely. Every parent of a minor child should have a will for that reason, as well as these others. A trust, on the other hand, isn't just a document. A trust is really a relationship. It's a legal entity that brings together someone, or we'll say someone responsible for looking after assets, money, investments, real property, for the benefit of someone else, whom we call the beneficiary. So a trust is sort of a living thing that will have a long life. A will, like I said, is a document that sort of has its one brief moment on stage, and then it's over and done with. You know, if you don't have a will when you die, there is an estate plan built into Maryland statute for you. If you die without a will and you leave assets that are in your name alone, not jointly titled, no beneficiary designation, and not in a trust, the state of Maryland says who gets what in what proportions, and there's no kind of fallback plan for protecting assets for someone with disabilities. So if you die without a will, stuff is going to get to the next rightful owner, but it's going to be according to the plan of Maryland as opposed to your plan. I've mentioned beneficiary designations a couple of times. These are a very powerful tool in estate planning, and powerful because there's so much wealth in our country today in retirement accounts. There's over $30 trillion in retirement accounts today in the United States. This is probably the single biggest vehicle for transferring wealth from one generation to the next. These are your 401ks, 403bs, 457 whatevers, IRAs, Roth or not. These are accounts that are not going to pass through the terms of your will. They're not going to be part of your probate estate. They're going to get to the next rightful owner by the instructions you put in writing for how you want these accounts to go when you pass away. So it's really important to stay on top of these, particularly as a trust becomes part of your planning, to make sure that if you want some portion of your retirement account to go into a trust for a child with disabilities, that the beneficiary designations are up to date and correct. Because if you name your child by name, you know, if that beneficiary designation says Mary O'Byrne, it's going to be mine. It's not going into a trust. If my mom wanted to put her retirement account into a trust for me, she'd have to say to the trustee of the Mary O'Byrne Trust that I created on such and such a date. So beneficiary designations are an incredibly important part of your overall estate plan. In that reference to a trust, we're going to speak briefly about special needs trusts. So this is a kind of trust intended for the benefit of someone with disabilities. It's intended to hold and manage and use wealth in ways that don't interfere with their eligibility for government benefits, like those we spoke about at the top of this presentation. And they're intended to make sure that the what's in the trust isn't counted against those $2,000 and other really skimpy resource limits. And this trust is intended to be used to enhance the beneficiary's quality of life. And generally, they're also intended to be used in ways that don't duplicate, rather that supplement what assistance the individual may have from the government, from their own earnings, or from other resources, so that we don't waste any of these. You know, we don't duplicate what the government benefits are, because that's just silly and wasteful. We want to supplement so that you're able to achieve sort of the best in all worlds. Your private support system from your personal wealth that you might leave in trust, as well as the government support system that your child might be entitled to as a result of their personal financial situation and their disability. We make a very big distinction between what we call first and third party trusts in the special needs trust world. And the difference here is whose money is going in the trust. If you want to prepare a trust for the benefit of your child into which you want to leave assets from your retirement account or your home or your personal savings or anything else, that's a third party trust. That's holding wealth that comes from someone other than the beneficiary. A first party trust is one that holds assets that only came from the beneficiary. This is a big distinction that we make, and the rules are very different for each type of trust. And this is something that you can expect to talk with an attorney about. It's also something that you can read more about in some of the resources that I have listed at the end of the presentation. So these are just some examples of how we might put a third party trust, special needs trust in place. You might have a trust under your will that says all my probate assets are going to go, or some portion, whatever portion you might want. Your will can say, when I've passed away, I want X% of my probate estate to go into a trust for my child, and that trust is described and created in the following sections. You might create a trust during your lifetime for your child into which not only you, but other people could contribute over your lifetime. And you might want to be able to change that more readily than it is, than to change your will. And we would call that a revocable trust, a revocable living trust that's also a special needs trust. Sometimes we work with families where someone wants to create a trust and put money into it, and they don't want anybody to change it. They don't want anybody to come back and fiddle with it. And in that situation, we would be talking about an irrevocable or irrevocable trust, one that somebody else can't change. My point here is that this isn't a one size fits all thing, that under the heading of special needs trust and third party trust, we have different ways to accomplish that, reflective of what your goals are and what your preferences are. The content of the trust in each of these examples, the language of it is would be very, very similar. These examples are different ways in which to establish the trust. In terms of first party trust, these come up sometimes when someone has accumulated wealth before they became disabled, or maybe family members had made gifts to somebody when they were young, and as they approach 18, there's a pot of money there that that is an obstacle to qualifying for benefits. They might have had an injury and received an insurance settlement that has resulted in money of their own. They might have received an inheritance that wasn't otherwise planned for. Those are all examples of situations where an individual could have money of their own that is an obstacle to their qualifying for benefits. In that situation, we're going to look at a first party trust. And I'll just say that the rules are different for first and third party trusts, and they're a lot stricter for first party trusts. And so both for SSI and for Medicaid, we have a lot of requirements that we have to meet in order to have a first party trust that's satisfactory to both of those entities. And generally speaking, one of the big requirements is that assets in a first party trust have strings attached to them when the beneficiary dies. And it is often an opportunity for the state to be able to be paid back for benefits that they have provided to the individual during their lifetime. And so when you have the opportunity to speak with a lawyer, or as you do, further research and reading about planning for your child, you're going to see this distinction between first and third party trusts. For all of my talking about trusts and drafting them and so forth, and there's some complexity to that, I got to tell you, the really tough decision is who's going to be the trustee. Who are you going to count on to be looking after the wealth that you're going to leave for the benefit of your child? Who's going to take care of that? And who's going to look out for your kid's welfare? And you'll see, I mean, this is my slide is meant to be somewhat humorous, but it really speaks to how tough a call that is, because we want so much from our trustees. We want to know and have faith that the people we're leaving in charge of our child's financial security is honest and true, and will do the right thing and will be smart about investing and so forth. Um, this is often the toughest decision. And you can expect in meeting with a lawyer, and something for you to be thinking about is how you might be able, different ways to be able to involve family members and friends who care about your child. We can have more than one trustee. That's one way to bring people in. We can have a role of what we call a trust protector, which is sort of like an advocate for the beneficiary. That's one way to bring other people into um, the picture of the trust. They may not be responsible for the money, but they can be looking over the shoulder of the trustee and helping to speak up on behalf of the beneficiary. It's also important to think about who can potentially change a trustee in the future. If a relationship isn't working out well for your child, who might have the authority to remove someone and appoint another trustee? And there are costs for trustee services. A trustee, whether it's you or me or a bank or a nonprofit, a trustee is entitled to be paid for doing this job. And so thinking about the costs of different types of trustees is also a part of that big decision. I've made a reference to ABLE accounts a couple of times in my remarks, and this is something that's somewhat new on the scene in the last, now probably about 7 years, so maybe not so new. But this is a type of tax-favored savings account for people with disabilities that allows folks to be able to accumulate above and beyond that $2,000 resource limit for SSI and for Medicaid, and to have funds that can be used primarily for their for what are called qualified disability expenses, for things that are related to their well-being or to their disability. And there's a lot of rules and requirements for the ABLE accounts, but if you can kind of thread that needle, the account itself is easy to set up and to access. So I've given you a link to the Maryland ABLE program here to get some more information. See, I told you I talked too much. I'm gonna come up to my last portion here, which in many ways is perhaps the most important one, talking about planning for a good life for your child in the future. And I think there can be so much focus as I've given here on the mechanics of government benefits and the technical decisions around decision making, around getting your documents in place. But it is so important to sort of pull back and really look out at the horizon, look out to the future, and think about what other things are going to be important in your child's life, and to help ensure that they can enjoy a satisfying and fulfilling life in the future, particularly when we as parents are gone. And what kind of circle of support are you going to want to bring together to help ensure that there are people around who care about your child and who will be engaged and involved in caring about them, not just caring for them, but who care about them personally. And some really key parts of that are ensuring that there's a safe and a secure place to live. And that might be something that someone can do independently, or that they may need some support. They may need more support and may need to be in some kind of sort of group or residential sort of arrangement. But there are a growing number of options in that regard, and just so important to strive to understand what your child wants in terms of where do they want to live, what kind of environment would they like to be in. I have seen from a big study that was done by the ARC in the last year or two of sort of different views by individuals with disabilities and the family members of individuals with disabilities about what their priorities were in terms of where they lived. And there's some pretty key differences, including the families put as a pretty high priority is living near family. It's like the second most popular thing. It's like living near the family. We want you to make sure you live. And the survey of the individuals with disabilities, that was like number 6 or 7 on the list. They wanted to be close to friends, and they want to be close to where they could do their errands and do their shopping, and public transportation. And it's like, yeah, it would be nice to be near family too. But it's just a reminder that we need to be listening to our children about what they really want. Um, and I think that sort of the notion of being able to be as active as one wishes in their own community. And and that may mean planning for help with transportation, for being able to engage with different organizations. There's a lot of different ways to be active in the community. And so as I'm sure you can appreciate, it's sort of it's a big menu. um, and I've touched on some of these points as well, that really listening to your loved one about what their vision is, talking with organizations, the community that you have here with the Benedictine school, the other family members, the other families, not family members, but the other families whose children may be in similar circumstances. There's a tremendous resource for all of you, to be able to be part of each other's lives to the extent that you wish to, but to know that there are other families um, uh, who who can help to be sort of informal uh, supports for the children of other families. I'm not saying that very very articulately. Um, Also, the importance of helping your child to learn to advocate for him or herself, to be able to speak up and express what they wish. Last thing in terms of this planning for a good life is a letter of intent. This is not a legal document in the way that the other things that I've talked about before, but it is a way for you and your child to be able to kind of capture and tell their story about who they are and where they're from and what they care about and what's important to them. It's an incredibly valuable tool. I think both in the creation of it as a way to really explore with your child and other family members what's important to you and to them, but a tremendous opportunity for insight for others who will in the future be involved in your child's care and looking after what you leave for them in trust. A trustee would find this a very very useful kind of tool, as well as staff and other support that may be involved in their lives in the future. I will send to Claudia a template that we have developed in our office, just for to be available to share with you as you may wish. Just sometimes, well, we all know that looking at a blank piece of paper is pretty daunting, and so it's just a way to perhaps get you started on the notion of a letter of intent. There's none of the requirements of a legal document. It doesn't have to be witnessed. It doesn't have to be notarized. There's no required format. So you may not like the one that we have, but it'll at least, might get you started. And I think I am coming to my wrap up, which is, as I said before, the kind of planning we're talking about really is a process. It's something that you're going to probably need to revisit from time to time. As you think about what your goals are for yourself, for your own planning, what your loved ones, their own goals are, figuring out, okay, how do I get there? What tools do I need? What steps do I need to take? And then taking that action and seeing how it goes. That is sort of the essence of the feedback loop of any kind of process. And uh, and I hope that you'll have a good journey in that process. Would be happy to help you in that. And lastly, I'm just going to point to a list of resources here at the end that can also really help you in that process and on that journey. You'll see references in the top two, the Special Needs Alliance and NALA, the National Academy of Elder Law Attorneys. What you can find here is reliable information. There's tremendous amount of unreliable information out there. And it's important to know that you can have trusted sources, and those are two that I can without hesitation recommend. Also, special shout out to the Maryland Developmental Disabilities Council, their document Planning Now, which is available online. You can download it for free. It's a comprehensive sort of planning guide for families and young people with disabilities, and goes through many of the topics discussed here and provides a bit more detail. And lastly, in terms of guardianship, the website of the Maryland judicial system, our court system has very, very good tools and forms and documentation available to help you learn more about guardianship as you sort of think about whether that's going to be the right direction to go in. This topic has gotten a tremendous amount of attention in our court system in the last 10 years, and the materials and the whole approach of the judges and the courts has improved a great deal. With that, I'm going to say thank you very much for your patience. I'll stick around for the questions, and it's really been a pleasure to get to speak with you this evening.
Thank you so much, Mary. That was great. What I'm going to do is I'm going to start here with the questions that are in the chat, and so that and then if people have questions beyond that, we can answer those. I know we've gone a little bit over, but I hope for those of you who have questions can stay on for a little bit longer to get a question. Here's a question from Sylvia. We did a trust a few years ago. It has no money. Question: the trust does not have a tax ID or number. How do I get that? Does the trust need updating from time to time?
First, on the tax ID question, depending on the type of trust, if the trust you created is a revocable trust, often that does not require a separate tax ID number, and it can often sort of live under the individual, the person who created it, who has the power to undo it and take the money back. It can often use that person's own social security number. But if there might be different reasons why getting its own tax ID number is helpful, and there's a particular form that the IRS uses. That's the SS4, which you can get at the Internal Revenue Service website, which is www.irs.gov. And if you search on forms, it's the SS4, and through that process, you can either submit it online, or you can print out the form and then fax it in. And sometimes the printing out and faxing can be a little bit easier just because the system online is ornery. It just, if you're not putting in exactly what they want to see, it can be very frustrating. If there are no assets in the trust, so that there's nothing earning income, which would be taxed, you might not need a tax ID number at this time. But once it does have assets in it and would be potentially creating income, you would have to have a tax ID number. And I'm seeing, Sylvia, you had another question further down that says, I tried to put the trust as a beneficiary. I'm thinking on a beneficiary designation, and couldn't because you didn't have a tax ID number. And that is sometimes a challenge with the beneficiary designation forms. Just can be a little difficult sometimes, but so your choice there is, it may be, and I'm not saying it is, but it may be permissible given the circumstances of your trust to use your own social security number, or you can get a tax ID number. And I appreciate that can be difficult, but it is, the folks at the IRS can be very helpful. And actually, if you read the instructions, which are usually many pages, but they're actually really helpful. I hope that's a.
Yes, I had my husband pull it from the lockbox, and I noticed that there's something that says document, and then there's like a 7-digit number. Is that it?
That wouldn't be a tax ID number. It has the same number of digits as your social security number. It's a 9-digit. Pretty sure it's 9-digit figure. So that might have had something else. But Sylvia, I'll invite you, if you my contact information is on the front of the presentation. If you'd like to shoot me an email, I can get you some more information about this.
Thank you.
Okay.
Thank you. The next, go ahead, Mary. There's the next question.
Sylvia, you also asked, does a trust need updating from time to time? And it may well, if you think about your child's lifetime, and the period of time over which you're kind of planning for them, it's not uncommon that things change in one's circumstances. Someone you named as a trustee may pass away, may become ill, you may no longer be in you may not get along anymore. They may not be the person you want to be the trustee. Other circumstances might change. Other family members may be born or pass away, and those who would be the remainder beneficiaries, those who would receive what is in the trust when your child passes, your decisions about that may change. The environment around benefits may change. You may move to another state. All kinds of things could change. And so it is something that you want to look at along with your other legal documents at a minimum every 10 years, and more frequently as changes occur that could have an impact on the use of that trust. So I really like to build in flexibility, and we'll more often than not we'll do revocable or revocable trusts for exactly that reason.
It looks like there's a question about a parent who's living out of state but whose child is here in Maryland.
We have a couple of different approaches here. A trust will be recognized and accepted in any state, and frankly probably in any country. And we have clients who have the situation you've described, and often what we'll do is to make sure that the content of the trust complies with Maryland requirements for Maryland medical assistance, that we've got the language in there that we know will satisfy them. We have a statute in Maryland called the Maryland Discretionary Trust Act, which can be invoked if the trust is being created for someone here in Maryland, even if the trust creator is in another state. And that sort of invocation of that statute is very helpful in terms of benefits protection. And so it could be set up in either state, but you would want to be sure that the content, that the language around the trustee's control you're going to want to check with somebody in each of these jurisdictions to make sure that it satisfies both of those requirements. And you asked about the different types of special needs trusts. I touched on that a bit in my presentation, and so I'm hopeful that I may have answered that question already.
Looks like there's a question about that you did touch on about a disabled son, but also a disabled parent.
Okay, so and it's Patrick, who I met at the very beginning. Depending on the amount that your son is receiving from your Social Security, he may be, if he's, and I know that you're muted, but I'll ask you to nod. Is your son receiving this benefit because he's a minor?
No, he's receiving the benefit because of my work history.
Right. And how old is your son?
He'll be 19.
Okay. So he's getting it now on the basis of his disability, not on being a minor dependent of a worker who was disabled. So he's getting this benefit because of his disability, and on your record, because he's your adult child with disabilities. If depending on the amount that he's receiving, if the amount is more than is allowed for SSI, he may only receive that Social Security benefit.
That's probably true. He gets $1,200.
Then he's not going to get SSI. He's not going to get SSI, and that's kind of great because because it's a lot less fiddly. It's because Social Security disability through your work record is not financially tested as SSI is. It's a much easier relationship with Social Security. And is he receiving services through a waiver program?
No, he has services, but not through a waiver program.
Okay.
He gets
Okay.
doors, and there's another one.
Okay. Got it. So SSI isn't really going to be in the picture for him because of this robust benefit that he's getting from you. So that's a good thing.
Okay.
Why would you ever want to go through probate since it is so restrictive? I'm not like a huge fan of things going through probate. I wouldn't necessarily say that it's restrictive, but there is a process that things have to go through, and there's a timing and required filings and so forth. And so we certainly strive to limit what goes through probate. My description of it earlier was not to be a champion for it, but simply to explain it. Is it possible for a layperson to create a special needs trust myself? Well, anything's possible. And I, don't mean to be snarky about that. Just that, and there are tools out there, like Nolo and Zoom Legal and things like that provide vehicles for creating documents. So you can. Something that I often observe is that there are many attorneys out there who are able to create a special needs trust, but they may or may not have the knowledge to be able to go beyond that and to talk about benefits eligibility, how things interact, sort of some of the complications that I talked about before. But you can. One may and one can create their own special needs trust. You can understand I probably don't recommend it, but it's possible. Does an SNT expire after they're unfunded after a period of time? No, that's a good question. Often, and when we are preparing a third-party trust for a family, we don't expect that to get funded until the parents pass away, and that's any time in the future. But the trust itself as a vehicle endures, and it is a legal document. It has established a relationship between the people creating it and the trustee and the beneficiary. And so even if it is on the shelf, as it were, for years, if it is identified as a beneficiary in a will or in a beneficiary designation form, it will come to life when it's funded. Does my office accept clients for special needs trust? Yes, I do. It's kind of what I do every day. And my information's on the front of the presentation, which Claudia's going to send out.
We had mentioned that at the beginning. Did anybody beyond what was in the chat, did anybody have any additional questions they'd like to ask Mary? And I know we're significantly over time, but we can probably take one or two and then leave it at that. But
I just want to ask, this is really significant because I'm in the middle of doing it right now. I live in Florida and you live, so can I get the Florida? Can I get the trust done, developed in Maryland?
You certainly may. And Ron, if you'd like to shoot me an email, I'd be happy to just to sort of go through what your choices are.
Yes, it's important. Yeah, because I'm in the middle of doing it now, and we'll be engaging with the Florida attorney for special needs trust. I found out there's only 200 of them in the state of Florida, special needs trust attorneys. But my son's in Maryland, and he will stay there probably the rest of his life.
Got it. And folks like me and those that you saw in that listing, we know that often families are spread out, and so it's not uncommon for me to get a call from somebody describing exactly your situation, and we can help accomplish making this work for you in Florida and in Maryland. We can help.
any additional questions? Okay, well, thank you so much, everybody, for joining us tonight. As Mary said, we will send out the slides and the form that she mentioned. And if you have any other questions, I'm sure we can follow up and get you answers. If you would like any information about Benedictine and his foundation, we're happy to also share that with you. And thank you, Mary, so much for this very informative and educational presentation. We really appreciate you taking the time and staying and answering everybody's questions. Thank you so much.
It's really a pleasure. Thank you so much for having me. I wish everybody a good evening.
Thany you and have
Happy
a good
spring.
evening.
Thank you.
Bye-bye.